Good afternoon, everyone, and thank you for having me here today. I'd just like to start by introducing myself. My name's Patrick Hartney. I'm a Senior Ombudsman at the Australian Financial Complaints Authority. Outside of work, I'm a father, a husband, a very poor but dedicated cricketer, a tragic North Melbourne fan, and a proud member of a regional community in Victoria. I'd like to start today by acknowledging the traditional owners of the land on which we're meeting, the Wurundjeri people of the Kulin Nation, and pay my respect to elders past and present. Today's session we're going to cover quite a bit. It's a bit of a crash course of AFCA 101. So I'll give you a bit of an oversight over who we are, what sort of complaints we receive, tips and tricks to maximising positive outcomes when dealing with AFCA, our approach to compensation, some case studies relevant to this area, and some tips and tricks to hopefully avoid us in the future. I'm going to try and get through this relatively efficiently because I want to make sure we've got some time at the end for any questions, and I'll be outside afterwards if anyone wants to have a chat or learn any more about what we do and how we do it. So about AFCA. AFCA came about 1st of November 2018 when the Financial Ombudsman Service, Credit Insurance Ombudsman and Superannuation Complaints Tribunal came together to form AFCA. So it's the one-stop shop now for financial complaint dispute resolution. Currently we're doing about 110,000 complaints a year, and as previously mentioned, that covers off not just financial advice and investment products but also superannuation, banking and insurance. So our responsibilities, a lot of people think of us as just complaint resolution. However, we've got some other functions, including identifying systemic issues and working with financial firms to resolve those. Also our reporting obligation to regulators such as ASIC and the ATO. And promoting awareness of AFCA both to consumer and industry groups, as well as putting forward submissions on changes to the law in the ecosystem we're working in. So AFCA's role in complaint resolution. So complaints and disagreements and misunderstandings are just a part of business. So sometimes it's good to get that third party, such as AFCA, involved to try and make sure everyone's on the same page and working towards an efficient resolution to the problem. It's good to sometimes having a circuit breaker can provide great assistance to find some middle ground. And help focus on the key issues in dispute, as well as providing some guidance around the law and approaches and an independent, unbiased view of the situation. AFCA's process is quite flexible and designed to enable the parties to find their own agreement up until the end of the process, where an AFCA ombudsman would deliver a final view. So the complaint would come through the door to AFCA. Whether that's been to the financial firm first or not may depend on what we do next, but if the financial firm hasn't had the opportunity to work with their client to resolve the complaint, we'll refer the complaint back to them. We then have a look to see if we have any jurisdictional concerns, and at that point in time the financial firm has the opportunity to make sure that the complaint is within our rules and can raise concerns. We then progress to case management. Now, during the case management process, we'll have one of our caseworkers working with the parties to do two main things. Firstly, to gather information, but secondly, to work with the parties to see if there's any way they can resolve the complaint via a mutual agreement. Now, there's a couple of ways they do that, either via shuttle negotiation through the course of the complaint, or holding a formal conciliation where AFCA would have a conciliator present with both parties on the phone to have a discussion around the complaint, including what each party believes the factual situation to be, but also what they believe a fair outcome to be. And we do have quite a high resolution rate through these early stages of the process. Now, if a mutual agreement cannot be reached during that process, the caseworker will deliver a preliminary view. Now, the preliminary view is an indication to the parties and a suggested outcome as to what they think an ombudsman would do in that situation. Now, it's just a recommendation, it's just a suggested outcome. So the idea is that if both parties agree to that outcome, then it's a mutual agreement, they shake hands, walk away, and it doesn't go through to the ombudsman. If one party disagrees with the suggested outcome, then it enters the final stage of the process, which is an ombudsman reviewing the entire complaint and delivering a final outcome. Now, that final outcome is binding on the financial firm. If a complainant accepts the outcome, if a complainant doesn't accept the outcome, then the complainant's free to do whatever they wish outside of AFCA. So it's the end of the AFCA process. They may choose to take the matter to court if they've got the resources available, or any other avenue they see fit. Now, what to expect from us when a complaint comes through the door. So it'll be an independent review of the process by someone who's got experience in financial services and dispute resolution. There'll be respectful engagement from us, and we are very proactive and keen to get on the phone to discuss the matter. So a lot of the time the parties will have had a lot of communication through writing. However, we always want to get on the phone to make sure we understand exactly what's happening with each party. If you've referred the complaint to a jurisdictional assessment, we'll assess that promptly to ensure that we're only dealing with complaints that are within our jurisdiction, to ensure that you're not spending time and resources on a complaint that we cannot consider. Or sometimes the complaint's partially inside the rules and partially outside the rules. So we'll trim it down and make sure that everyone's focused on the issues that fall within AFCA's rules. And then our caseworkers and decision makers will use their experience to tailor information requests that are going to assist the parties in getting a mutual understanding of what the other one is saying, but also to establish what the factual situation is to be able to deliver a fair outcome. So I want to run through some complaint statistics, and we're sort of going to start big, going through all of AFCA into then investments and advice, and then what we've got where managed discretionary accounts have been listed as the complaint product. Now, SMAs, we don't have the specific stats on SMAs, but MDAs have been recorded over the last couple of years. So these numbers are based on 1 July 2025 to 31 December 2025. So as you can see there, we've received 57,000 complaints. So that's reasonably consistent with the 110,000 we received last financial year. Now, you look at the donut there, credit and general insurance are making up a huge amount of the complaint volume, and in the investment side of things is about 3,000 up there in the blue, so about 6%. So a relatively small percentage of overall AFCA. But I think what needs to be taken into account there is the percentage of the population that have these sort of products or receive these sort of services in comparison to, say, bank accounts, natural disasters with the general insurance, and superannuation. So of those 3,100 complaints we received in the 6 months in investments and advice, I think it's really important to sort of understand the context of this and the driver of a lot of these complaints. Now, this is a period in which we've had some very significant events occurring in the investments and advice space, and we're talking about the Shield and First Guardian events, which has impacted a lot of consumers, the same as the Dixon collapse, same impact the Dixon collapse had earlier. So when you look at the sorts of complaints we've got, a lot of them relate to superannuation fund, which is where we're sort of seeing advice when you look at the product next to the issue. So you can see the product super, but then when you're looking at the issues we're experiencing, failure to act in clients' best interest, failure to prioritise clients' interest, inappropriate advice. So there's a lot being generated based on the quality of the advice. So that's where we're sort of finding a lot of those Shield and First Guardian issues sitting. On the right-hand side, we've got some data about when complaints get closed. Now, you see that we've got, of the 2,400 we closed in that period, 700 are being closed at decision. Now, that's quite a high percentage for what we normally experience. Now, a lot of that's being driven by dealing with financial firms that are in liquidation, so we don't have the options available to us to be able to try and negotiate or settle with the parties. So we do have a more efficient and a more efficient process with those complaints. You can also see there that of the 2,400, 400 of them were actually closed at the jurisdiction stage. So that's where either AFCA's identified a jurisdiction issue or it's been brought to our attention by the financial firm and we've discontinued considering the complaint. So that's, I know I'm going to go through the tips in a second, but that is probably my number one tip is if you've got concerns about jurisdiction, make sure you raise them as early as possible and familiarise yourself with the AFCA rules and operational guidelines. And probably it's a really positive one, the 560 in referral. So that's where AFCA really hasn't had to intervene. A complaint's been raised, it's been lodged at AFCA, and in the refer back period, the financial firm has been able to resolve the issues with the complainant. And then we've got our time frames there. So the more than 365 days, that's certainly being skewed by these bigger events where complaints may have been on hold for quite a while. When we condense that a bit down to MDAs, you can see in the 6-month period we've only had 10 complaints registered where the MDA was listed as the product. Now, that data is only as good as what's being input into it. So sometimes the client may not be completely aware of exactly what product they've got or what product they're complaining about and may say something like, I'm complaining about shares, despite the fact is they're complaining about the advice on the MDA as opposed to the actual specific share. The other sort of complaint that I'd almost classify as part of the MDA group of complaints which wouldn't be captured in that is the unlicensed MDA conduct. Now, fortunately, that's not something that anyone in this room that's part of this association would ever have to deal with, but we do see from time to time complaints around discretionary trading when the structure wasn't in place and the licence wasn't there, and that's where our systemic issues function comes into play, where we do have an obligation to be reporting serious misconduct or systemic breaches to the regulators if we observe that sort of conduct. So you can sort of see there we're only dealing with a very, very small sample size for that 6-month period, and then over the previous financial year, just the 13 where that was the product. Again, there's some complaints around failure to act in best interests, some stuff about some fees there, and a lot of them are progressing through to decision. The one thing I'd say about that is that a lot of the times with these MDA complaints, they do tend to be higher value. So it can be more difficult to try and find a middle ground where one party's looking at zero and one party's looking at 400,000 or 500,000 for a claimed loss. If you are interested in AFCA's data and what's available, we do have the data cube there, which is a free public resource where you can slice up complaint volumes based on specific products, specific business sizes and primary business types, specific firms over a range of different periods. So that's available, readily available on the website, and if you've got any interest in seeing how things are tracking, that's there for you. So some tips in maximising positive outcomes with complaints. Now, normally the financial firm will be the first port of call when a complaint arises. The client may raise the complaint directly with their advisor. So it's just really important that the advisor is aware of the escalation points and what needs to happen and who the complaint needs to be referred to, what the timeframes are to respond, and just it's important to remember tone and content. So sometimes these issues can be quite emotive and it can stem from a long-standing client relationship, which can be really difficult to deal with. So we always really encourage people to just deal in the facts, and that can be one of the most effective ways to resolve a complaint. So that's sort of covered off what I just spoke about then. The communication is really, really important for that first impression from the complaint handling process. So tailoring the complaint, not leaning entirely on templates, and being able to make sure both parties understand what the complaint actually is about, because a lot of the time you do have complaints coming through the lower stage of our process which do get resolved very quickly just because there has been some misunderstanding between the parties about what actually is being complained about. So you could have seen these avoided potentially with a really clear understanding being reached between the parties at that early stage. Unreasonable behaviours is something that we do see a bit of, and it's unfortunately, and like I hope not for anyone in this room, but something that you may have to experience with the complaint resolution process, that it can be a really emotional time for people. So it's important that the people dealing with these complaints have got the adequate training and policies in place to be able to de-escalate these situations, as well as being able to have the referral services such as mental health or financial hardship or anything along those lines in place and readily available to refer to should they be required. So when a complaint comes to AFCA, we just always feel best practice is just being willing to listen. We've got a lot of really experienced staff that deal with these problems every day, and they'll be asking questions and seeking information from each party with the purpose of finalising the complaint, whether that's finalising the complaint through a negotiated outcome or being able to get the complaint to a stage where a final decision can be issued. So we just ask of people just be really open and respectful in dealing with our process. I just want to touch really quickly on AFCA's approach to loss if we do find in favour of a complainant. This is a presentation from a presentation that we did a little while ago at the AFCA Members Forum, if any of you tuned in for that one. Now, there's sort of three windows up there in terms of how it could be loss could be viewed. The first is a counterfactual estimate. Now, this is where we place the complainant in the position that we estimate they would have been in had they received appropriate advice. Now, that one we've sort of been using with the Dixon complaints because their portfolios are a bit more actively managed, and it's very hard to try and reverse those transactions and say what would have happened over a long period of time. So that's where we use one counterfactual fund to estimate the market exposure that person would have had based on appropriate advice. The counterfactual no transaction is what's being used predominantly for Shield and First Guardian complaints, where the complaint really is my superannuation was rolled out of an APRA-regulated fund into these other products, where the appropriate advice would have been, well, everything was okay in your APRA fund. So we use an assessment of loss based on what that APRA fund did. And then the final one is the actual or capital loss, which isn't necessarily as fair or accurate as the other two, really based on its getting the advisor to underwrite market performance. So if markets are down, capital loss may not be the cause caused by the advice. It could just be markets. So we need to be able to compare the actual performance with what was available at that time, as opposed to saying you've lost money, that must be the advisor's fault. So the counterfactual approach is based on significant case law, which is up on screen there, and it's considered to be the fairest approach to assessing loss. Now, I've got 3 case studies that I've been able to have a look at that related to MDA complaints. So I don't want people to walk away from this presentation thinking that AFCA is always saying that an MDA complaint is going in favour of the complainant, but I think it'd be a pretty boring presentation if I was only presenting times when everything was right and no one's taking anything out of that. So the first involved a complainant who was 68 years old and retired. She had about $300,000 to invest in super from the sale of a farming property. She was recommended to set up an SMSF and invest in an options trading strategy through an MDA. The fees were $47,000 over 3 years, and the financial firm's own website suggested that you needed at least $500,000 to invest in that sort of strategy. The finding was in favour of the complainant that it was just too risky, too complex. She just didn't need that strategy. The statement of advice never really explained what the benefit to her in that was, and we found in favour of the complainant. Now, I just want to make a note about all of these as well. These are all readily available on our public website, so you can search decisions based on these case numbers, but you can also search based on keywords, terms, different product types, product issues. So it's a really good resource to sort of understand how AFCA views these matters. The other thing that's probably worthwhile noting on these, I think all of these were actually panel decisions. Now, a panel decision is where AFCA determines that the fairest way to resolve the complaint is, instead of one ombudsman making a decision, we appoint a panel to make the decision. So it'll be an ombudsman, someone with significant industry experience, and someone with significant consumer advocacy experience. So the three people will sit down and have a discussion around the facts. Now, it's not the consumer advocate's role to advocate for the consumer, it's their role to talk about what consumers generally expect, the same as the industry person. They're not there to advocate for industry, they're just there to explain what industry practice looks like. So it's a mechanism we use quite regularly as a way of delivering fair outcomes. So the second case there we've got in the blue, there was a recommendation in relation to an SMSF and a family trust. The SMSF recommended establishing it and setting up the MDA. The SOA was seen to be quite defective. It really downplayed the costs of entering that strategy, like we're talking really significantly downplayed, and then just didn't really do anything to explain why they needed to get out of their existing funds into this new strategy. So it was found that that was inappropriate. The family trust had a bit of a different finding. They sort of felt that the panel felt that the MDA was actually appropriate within the family trust, but the problem there was the MDA was invested significantly outside the agreed parameters for almost the entire relationship. So again, there was a finding in favour of the complainants. Now, the final one is an interesting complaint that involves two financial firms. So AFCA has got the ability to join financial firms to the same complaint if we consider that it would result in an efficient way of resolving the complaints, especially when the case indicates that both financial firms could be responsible for the same loss. So in this case, we had financial firm 1 that was using the MDA to trade for the complainants, and they were using financial firm 2's platform to do so. Now, they were trading margin FX. Both FFs had classified the complainant, which was an SMSF entity, as a wholesale investor using the $2.5 million test. AFCA and the AFCA panel found that the appropriate test for an SMSF was the $10 million. And therefore, the leverage that the complainant was able to access, the 1 to 1,000, shouldn't have occurred. And the panel ended up dividing the total loss 3 ways. So they said, okay, 1/3 to financial firm 1, 1/3 to financial firm 2, and complainant as the responsible person for the SMSF needed to take some responsibility as well, based on their experience and knowledge of what was happening. So that was that finding, which covers a few topics with joinder and apportioning loss and contribution. So the top 10 tips for complaint to avoid complaints. So taking detailed file notes is extremely important. It's often that a complaint comes to AFCA and we get given a story by one party, then get given a story by another party, and neither party has much contemporaneous evidence to support what they're saying. So really, as a decision maker, I'm trying to put myself into that meeting from 5 years earlier, which can be really, really difficult to do. So any information or evidence that's taken at the time can be really useful to support your position. Clearly explain the scope of the advice. We often see complaints where the scoping is either too narrow or too broad. and it creates issues down the track with misunderstandings about what actually is being advised. Having a clear understanding of the client's goals and objectives is really important to providing good advice when it comes to MDAs and any other financial product. Often we see objectives that are really vague and broad and very, very hard to measure. And that's where it can be a lot more difficult to justify the advice if it's unclear as to what it's actually trying to achieve to see if it is meeting the client's best interests. Having a good understanding and explaining the products recommended, it's not uncommon for us in these MDA complaints to see people, and by that I mean the complainants, complaining about the discretionary nature of the product, which for me, when you're sort of seeing that written as a primary issue in the complaint, you start to question about what sort of understanding the person had at the time of the advice. Providing good reasons to recommend a switch is, as you saw from those previous case studies, turning clients away if necessary. So if your business can't provide the appropriate service for that client, whether it's too complex, too simple, too high value, too small value, whatever it may be, don't provide the service if you don't if it's not going to be if it's not going to be in the client's best interests. Using risk profiling tools carefully. We do see them used without much analysis, I guess is the way I'd put that. So a ticker box exercise, not really reflecting on what specific answers are being given to determine what the appropriate risk profile is for the client. As touched on earlier, and as I heard in the previous presentation, managing conflicts of interest adequately. So prioritising the client's interests ahead of your own. Documenting carefully if the client wants to act against your advice. We often see that at the other end, which is when the complaint happens, the defence being used is that this was client-driven, not advisor-driven, but there's no documents to support that view. And making sure that the consumer provides informed consent to the advice. So they're signing off on authorities to proceed. You've got good paper trails of that. If you're using DocuSign, that it's clearly done on the complainant's behalf. So that's our top 10. And don't know, I've got 3 minutes for questions. So has anyone got any questions or anything they wanted to raise?
There should be questions. Yeah, Deanne, you first.
Thank you. You gave some really good case studies about things when they go wrong. You also mentioned the other part of your role was really around those identifying systemic issues. Is there anything there that we need to be aware of, or is it more those isolated cases that you've spoken about?
Yeah, it's look, while I can't sort of go into any specifics, we do have a statutory obligation that if we identify anything that we consider to be systemic, so if that impacting more than one of your clients, or something that's serious misconduct, we need to report it to the regulators. So I think a good example of that serious misconduct is where I was saying that we do see the unlicensed MDA happening occasionally, where someone isn't even licensed by ASIC to provide MDA services, but then just doesn't tick any of the boxes as required under the reg guides or anything like that, and it's just trading on a discretionary basis. So that's something I'd consider as serious misconduct and would be reporting straight to the regulator.
I've got a question which comes up, often, which is wholesale and SMSF, and you touched on it in one of your case studies. Personally, I've always worked on the principle that SMSFs are retail, unless they've got 10 million, and I haven't come across that many of them. Not since last week. No, that many of them. But you can get legal advice which says if the trustees personally qualify as wholesale, so you can treat the SMSF as wholesale. What's AFCA's view on an advisor who has treated SMSFs as a wholesale?
Yeah, so consistently over a couple of years now, we've been assessing SMSFs based on the $10 million professional test as opposed to the 2.5, regardless of the trustee. That's a position that we've taken to membership forums. We've published the decisions. And ASIC, look, while I think it was someone's going to correct me, but 2014 or 15, I think, when they said that they weren't going to take action themselves on this issue, they did say that's not going to stop anyone taking a private action, and that's where we'd consider a case to AFCA or a court would be seen as a private action. And look, AFCA just takes into account the law, good industry practice, and what's fair in all the circumstances. So those pieces of legal advice that you're referring to, I mean, we're always going to take into account submissions on a point, but that's our position as it currently stands.
Any final questions for Patrick? Oh, Toby, can we get a microphone down table 3, please?
Sorry. Right after right after Royal Commission, I had the privilege to work for one of the big accounting firms with regards to auditing files. Now, a few files I came across that upon making a complaint or lodging a complaint to AFCA, the practices had to actually pay a fine, but you just mentioned that it was free. Could you maybe explain a little bit or provide some context around that, please?
Okay, now that fine wouldn't have come from AFCA. I can't comment on, I'm not sure about the specific case you're talking about, but AFCA doesn't issue fines. We're not a regulator. We're purely looking at resolving each complaint as it comes in. So even if we receive 200 complaints against the one entity, we'd report that as systemic to a regulator, who the regulator may issue a fine, but AFCA just awards compensation to a complainant if we feel that a financial firm has breached an obligation to that complainant and that breach has caused a loss. So while AFCA is free for complainants, we don't have any ability to issue fines or suspend licences or anything like that. If I had to guess about what you're referring to, I'd say that there was an ASIC investigation, and as part of that, the financial firm received a fine and were required to undertake a remediation program. And then as part of that remediation program, they would have to notify their clients of the existence of AFCA. And if they disputed that remediation outcome, then they could go to AFCA. But again, just having an educated guess on that one.
All right, well, please join me in thanking... one more. Wow, lots of questions on this one. Thank you.
Just one more. What's the stance in regards to a financial advisor actually assisting a client with an AFCA complaint application?
We're open to complainants having representatives, whether paid or unpaid. Look, our system is designed so a complainant doesn't need representation, but I mean, we understand that some people don't have the same level of education or expertise and may require assistance in doing so. So we wouldn't prevent a complainant engaging a representative to assist them through the AFCA process.
Yeah, I guess where I'm sort of treading is in regards to a handful of the MWL clients that are not literate enough to know what to have to do, and basically getting information stating that they should refer to AFCA, and they basically don't know, what to do, whether it's they're on board the class action automatically, or whether they have to sign into it, or what the scenario is. So I just wanted to know, will it affect the advisor that is actually helping that particular client in any way, or is it something that is a good practice, a best practice way of going forward?
Well, look, if you have a client that you feel has been wronged, I mean, AFCA can accept a complaint about the former advice they received, and you can be the representative for that person. In relation to class actions are entirely separate from AFCA, and AFCA wouldn't be lodging complaints on behalf of anyone. So it's entirely up to the consumer that feel, or their representative, if they feel they've been wronged, to lodge the complaint against the entity that they feel has wronged them. And it's really important that that occurs while that entity is still an AFCA member, because once the AFCA ceases being once the financial firm ceases being an AFCA member, that complaint may be outside of our rules. So if you are considering lodging a complaint, I'd encourage you to do so sooner rather than later.
Also came out, with reference to AFCA as well as a class action. So it was a bit of
Yes, I'm not entirely sure which email correspondence you're talking about, but I'll be here afterwards if you want to have a chat about it off stage, just so I can provide some guidance and assistance if required.
Okay, Patrick, you win the award for most questions.
Oh, really?
More still.
Yeah, one more. What's your view on definition for wholesale clients and retail clients? Because there are wholesale clients by asset that meet wholesale clients, but they can simply just argue that, or from the technical point of view, that they don't understand anything. So what is AFCA's view on this sort of situation?
Okay, there's a couple of layers to that one. So the first classification you're talking about there is wholesale based on either net worth or income. Now, the requirements there under 761G just require an account certificate. So it's a lot lower bar to be classified in that way. Because of that, AFCA's less likely to exclude a complainant that's classified as wholesale based on the net worth or income, because it's not as apparent to them the consequences of that. However, we could still assess the complaint, but we're not going to treat them with the retail protection that they're appropriately classified. The category that you're also discussing in terms of their knowledge and experience is under 761GA, which is the sophisticated investor. Now, that's a category that we're more likely to use our discretion to exclude a complainant if they're properly assessed and it's made clear to them that they are giving up their retail protections, which includes AFCA, and that assessment's made on their experience and understanding of the product they're getting themselves into based on what they've previously done. So there's sort of two different tests, but if someone's been properly assessed as wholesale and we consider the complaint, we'll treat them as a wholesale client as opposed to having the best interest duty and other retail protections that may have been available to them as a retail client.